Good morning, folks. Hope this finds everybody well. It is a beautiful morning here in Hopi, America. So, what I'd like to do today is obviously go over it's an overview of Public Law 10297, and we'll talk a little bit about the fund flow in the Bureau of Indian Education, how the money gets to the grantees. And then some provisions of 638 that applies to Public Law 93638 that applies to 10297 grants. And please, if you have questions as we move along, don't hesitate to do your, I think it's *1, so we can stop and answer your questions. So, all right, with that, we're going to go ahead and move forward. So this is the overview of Public Law 10297 grants. The Bureau of Indian Education has a couple of fiscal years that impact how the funds flow within the Bureau of Indian Education and how that gets to the tribally controlled schools. We have, for the majority of our funds, the fiscal year runs July 1 to June 30th. And these are interior funds like ISEP, transportation, administrative costs, and Department of Ed monies, Title I, Special Education Part B. Those run fiscal years July 1 to June 30th. We do have one pot of money that runs with the regular government fiscal year of October 1 to September 30th, and that is their facility operations and maintenance funds and other facility-related funds, like minor improvement and repair. And minor improvement and repair are those repairs that cost $2,501 up to $100,000. And then facility improvement and repair funds are any major project that exceeds $100,000. So these are all facility-related dollars, and they run October 1 to September 30th. So when in the grants, for the most part, the majority of your funds will be showing a fiscal year of availability from July 1 to June 30. And then you're going to see facility operations, and you don't get those until October or after October. And then obviously it also depends on whether the Congress approves an appropriations bill, or if they don't, normally they'll continue authorizing continuing resolutions, and we'll get bits and pieces of dollars for operations and maintenance and other facility-related programs. The interior funds flow directly from the BIE financial analyst to the education line officers. Now, the education line officers are also designated as the grants officers according to Public Law 107-110, the No Child Left Behind Act, which amended Public Law 100-297. And these are, the funds go down for the initial awards if you had just converted to a tribally controlled school. Those dollars will go to the grants officer, who is the ELO, and then on down to the grantees. Subsequent amendments work the same way. Once all of the documents, the amendments are made to the grant, the grantee accepts by signature the amendments, then the dollars will go into the grants and then eventually paid out to the grantees. We have forward-funded dollars that are appropriated annually by the Congress. Funds are appropriated by the Congress in the prior fiscal year to be expended in the subsequent fiscal year. What that means is, for example, the funding that's going to be available for the grantees for the schools come July 1, 2015, were approved in FY14's Appropriations Act. So when July 1 comes around, you will already have ISEP, administrative cost grant money, as well as transportation dollars. And these dollars are put into the grant on July 1 at 80% of what you received in the prior year. Now, the Department of Ed funds, let me see, Department of Ed dollars, the BIE has in place a memorandum of agreement to receive these dollars from the Department of Ed that flow through the BIE and then to the grantees. There's one exception on funding that flows through the Bureau, and that's Title VII, the supplemental education dollars. These dollars, when you become a tribally controlled school, no longer flow through the Bureau of Indian Education. You as a grantee then deal directly with the Department of Education to receive your Title VII dollars. And all of the Department of Ed monies are effective July 1 of each year. And they are considered multi-year funds. Some of them are 27-month monies, whereas ISEP, administrative costs, transportation, are 15-month monies. However, tribally controlled schools do not need to worry about the ending dates on these dollars, because one of the provisions of 638 that applies to tribally controlled grants, school grants, is that these funds are available to the grantee once they're put into the grant until expended. We'll go over the reporting here in just a few minutes, but that's how the grants work at the schools. Now, it's critically important to know that although the memorandum of agreement states that we should be getting those monies on July 1, we normally do not receive them on July 1. Rather, we receive them sometimes in September, sometimes in October, and sometimes even later. But the BIE puts these dollars into the grants as soon as we get these dollars. Now, the BIE has an internal policy where grants officers are required to turn these dollars around quickly. And the timeline is within 3 days. The majority of the time, these are the grants, the monies going into the grants are done within the 3 days. There are times when those days are missed, but our target date within the Bureau is try to get these funds out to the schools within 3 days. What is a tribally controlled school? The definition of tribally controlled school comes directly out of Public Law 107-110, again, which amended 100-97. And this is what the definition is. A school that is operated by an Indian tribe or tribal organization enrolling students K to 12, including a preschool. Now, the preschool money that the Bureau has is early childhood money, which funds our FACE programs. And that's the only preschool money that the Bureau of Indian Education has. A tribally controlled school is not a local education agency and is not directly administered by the Bureau of Indian Affairs. So this is the definition that comes out of the statute itself. Okay, so what statutes, regulations, and circulars apply to grants under the Tribally Controlled Schools Act? Well, of course, the Tribally Controlled Schools Act, as amended itself, applies to these grants. There are regulations that are contained in 25 CFR, Part 44. And if you've not seen the regulations, it's a good idea to get a copy of 25 CFR and walk through that section of the regulations that talks to tribally controlled schools. It's not very long, and it's put in the regulations as a question and answer format, and it's pretty easy to follow and read. Any guidelines, manuals, and policy directives. Now this is important, agreed to by the grantee. So if something is not required by statute, if it is not required by regulation, but if they are guidelines, manuals, or policy directives, then the grantee needs to agree to these. What are some examples of guidelines, manuals, policies? The suspected child abuse reporting procedures are a policy of the Bureau of Indian Affairs. There are a lot of grantees that have actually taken formal action to adopt these reporting policies and procedures and are using them. And I think, in fact, the Navajo Nation has approved the policies and procedures in full and require their grantees to follow these guidelines. Driver's license checks is a policy within the Bureau of Indian Affairs. Grantees can adopt these policies and require driver's license checks annually like the Bureau does. Just a couple of examples of policies that are not required by regulation or statutes, but I think makes good sense to adopt them. there are certain OMB circulars that apply to tribally controlled schools grants. And these are OMB circulars A87, which is the allowable and disallowable costs. OMB circular A102, which is the uniform administration of grants. And A133, which are the Single Audit Act requirements. Now, all of these circulars are being replaced effective December 2014, and within the next week or so, all of them will be replaced by 2 CFR Part 200, and it's being referred to as the super circular that's going to essentially be applied to all grants from the federal government, including the tribally controlled schools grant. They have taken the allowable, the disallowable, the administrative portion, and the audit requirements, and they put all of those into one document. And you can search the internet for 2 CFR Part 200 and get a copy of it. But that's going to be effective within the next week or so, and it replaces again 87, 102, and 133. Okay. So how can the funds in the grant be utilized? The statute basically says that funds can be used for school operations, academic, educational, residential, guidance and counseling, and administrative purposes. You can use the funds for support services for the school, including transportation. And at the discretion of the school board, can be used for facility operation and maintenance program. Now, you can also include in the grants, we talked about minor improvement and repair dollars, facility improvement and repair dollars, and you can also include new school construction dollars in these 10297 grants that are available to the tribes, and in most cases are operated by the school boards, who become the grantees for the grants. Here's some general questions that sometimes comes up as we're talking about 10297 grants. And first one is, may grant funds be used for religious worship or sectarian instruction? Funds may not be used in connection with religious worship or sectarian instruction. Now, when we begin talking about tribal culture, tradition, language, those are not considered religious worship or sectarian instruction, and therefore are allowed and can be developed as programs within the schools. In fact, there's right now a big push from many different directions on developing and implementing tribal culture, language into the school curriculums within the schools that are funded by the Bureau of Indian Education. How many grants can you get per year? The law says you cannot have more than one grant per year per tribe or tribal organization. Now, that means that all of the money coming from the Department of Interior for educational purposes, ISEP, administrative costs, transportation, and all of your Department of Ed monies going to a given school, all go into that one grant. Now, if that school is getting minor improvement and repair money, facility improvement and repair money, or even new school construction money, it all has to go into that one grant, because the law says you cannot have more than one grant per year per tribe or tribal organization. There's different requirements for any facility improvement and repair project or new school construction project that exceeds $100,000. And we'll talk about 43 CFR Part 12 here in just a minute. Okay, so how does the grant, if a tribe or tribal organization converts their BIE school to a tribally controlled school grant, how does the grant affect federal responsibility? The grant shall not terminate, suspend, modify, or reduce the responsibility of the federal government to provide a program. And I hear stories at times where people say that the federal government is getting out of the education business and they don't want anything to do with grantees once you convert to a grant school. The federal government still has a trust responsibility for providing education services to Indian students, Indian tribes and tribal organizations. So just because you convert a school from a BIE operated school to a tribally controlled school, the federal government is still responsible for being there to provide the program. As well, the Bureau of Indian Education is responsible for providing technical assistance to make sure that these grants are successful. And the grantees should expect that from the Bureau of Indian Education. By the way, if you have any questions, please do your *1. Thank you. Okay, once a tribe or tribal organization grants a school, can they retrocede? And if they can, how is this done? Yes, a tribe can retrocede a grant back to the Bureau or to a 638 contract. Only a tribal governing body that authorized the initial grant can also take formal action to pass another resolution and retrocede it to either a Public Law 93638 contract or back to the BIE as a federally operated school. Now, what is the difference between 93638 Can you hear me?
Yes, I can hear you.
I guess there's some, excuse me, apparently there's some folks that can't hear or something. And I'm not sure how to fix that, Matt.
Yeah, I put the teleconference information on the chat section. I suppose everybody that's listening to us now has the correct one, but I did put it on the chat section on the presentation.
Okay. All right. So, where was I? What's the difference between a Public Law 93638 contract and a Public Law 100-297? There's some major differences between the two. First of all, Public Law 93638 normally is a contract that is made between the federal government and the tribal governing body. A 93638 contract requires a scope of work, a budget narrative that has to be submitted to the Bureau of Indian Education, and then it's submitted to the Bureau of Indian Affairs Self-Determination Office to be awarded by the Bureau of Indian Affairs. The Bureau of Indian Education does not have the authority to award 93638 contracts. The Bureau of Indian Education becomes an approving office when a tribe decides to convert to a 93638 contract. So the BIE would then provide recommendations to the awarding official whether to award the contract or not. So the four major differences are: one, you have to have a scope of work for a 638. You do not need a scope of work for a 100-297 grant beyond what was articulated in the application to convert the grant. 93638 contractors are required to submit a budget and a budget narrative for the funds that are going into the contract. A tribally controlled schools grant does not require submission of a budget or a budget narrative annually. A133 audits. The Bureau of Indian Education right now addresses and resolves all deficiencies in A133 audits for tribally controlled school grants. The Bureau of Indian Affairs awarding official is the one that deals with all A133 audit findings and deficiencies and is charged with resolving those findings. So there are some major differences between a 100-297 grant and a 93638 contract. The payments are essentially the same. The ability to invest the funds once you get them are essentially the same between a grant and a contract. But again, those four differences are pretty major. Now, if a tribe does not want to retrocede that to a 638 contract, they can give it back to the Bureau of Indian Education as a federally operated school. Now, if a tribal governing body formally authorizes the retrocession, the director has exactly 120 days from the date they receive the authorizing resolution to take the school back and begin operating the school as a BIE operated school. Unless there is a different date that is negotiated between the director and the tribe. So either if a tribe is going to retrocede back to the Bureau as a Bureau-operated school, director has 120 days, or a date that is negotiated between the Bureau and the tribe. But you can retrocede back to those two options. Are there any administrative cost limitations for the grant? This is what the law says. Grantees may not expend administrative cost funds in excess of the amount generated. However, this is one of those line items in Indian Affairs budget that is not fully funded. So currently, grantees receive approximately 62%, give or take 1 or 2, of funds they are entitled to under the formula. Every year, our finance specialist out of Washington, D.C. sends out a document to all of the grantees that lists the amount of educational dollars that were put into the grant for the previous year. And then the grantee then confirms that the numbers are correct and then sends them back into central office in D.C. These are the numbers that determine your direct cost base that is part of the formula for administrative cost, and that is used to calculate your administrative cost rate. Now, there is a difference in how rates are calculated depending on whether you are a tribal organization or a governing body that's determined to be the grantee. The concept of the administrative cost formula is the bigger the direct cost base, the smaller your administrative cost rate. And the rate becomes important at the end, and I'll get to that point. When the direct cost base is being determined for tribal organizations, and normally tribal organizations are school boards. Sometimes they're Department of Ed within the tribe, but for the most part, they are school boards. So if a school board is the grantee, how the direct cost base is determined is they take all of the instructional dollars, they take all dollars that were incorporated into the grant in the prior year, and that determines the direct cost base to be plugged into the formula to determine your administrative cost rate. The difference is if the tribal governing body is the grantee, not only do they include the dollars that went into the grant, but they also include in that direct cost base all non-construction and social service 638 contracts are taken out, but they take all other 638 contracts and add that into the direct cost base to determine your administrative cost rate. Now remember, the bigger the direct cost base, the smaller your administrative cost rate. So that essentially means that if you're a tribal organization, you're only going to include the dollars that went into the grant to be used as the direct cost base. If you are a governing body and you're the grantee, not only do you include the dollars that went into the grant, but all 638 contracts minus construction and social service contracts to determine your direct cost base. Now, what happens or how is the administrative cost rate used? The administrative cost rate, once it is determined, then is applied to your current year's funding. So say in last school year, the total amount of money the grantee received was $1 million. And for this year, say they're getting the same amount of money, $15 million or $1 million. But say their administrative cost rate is 15%. Then they take that 15% and they multiply that times the $1 million. And that determines your administrative cost need, calculated by the formula. So if you multiply 1 million times 15%, that is $150,000. The formula says you should be receiving. And remember, because the administrative cost grant line item, they now call it grant support costs, are not funded at 100%, but only at 62%. That means if the formula says you're entitled to $150,000, you'll get $93,000 from the Bureau for your administrative cost grant. So essentially, you're not receiving all of the money that the formula says you're entitled to. So during one of the audits within the past few years, there was a finding at STASI, who is Shiprock Alternative Schools Incorporated, operating out of Shiprock, New Mexico. There was a finding in their audit report that said that they overexpended their administrative cost grant dollars. They had received $100,000, but they spent $150,000, for example. And the grants officer, after reviewing the audit, sitting down with the grantee, reviewing the reasons why they overspent $100,000, disallowed the $50,000. then SASE came back and said, that's not right. The formula says we were entitled to $150,000. So we spent $150,000. The Bureau only gave us $100,000. The grants officer disagreed and disallowed the cost. So SASE then sued the Bureau of Indian Education and took us to court. And it was a court in New Mexico where the judge determined that grantees are entitled to spend up to the amount that is determined by the administrative cost grant formula, even if they receive only 62% for that purpose. And the decision says it allows grantees to use ISEP and other grant funds to make up the difference between what the formula says the grantee should receive and what they actually received under the grant. So if a grantee gets $100,000, but the formula says they should get $150,000, they can use ISEP, Department of Ed funds, or other dollars to make up that $50,000 to spend up to the amount that was calculated under the formula. Now, there's a couple of things. One, it has to be reasonable in terms of how much money you take out of a program. For example, Part B, special ed. You can take a portion out of there, but it really has to be reasonable because that given program is specifically set aside for special education students. You can take a reasonable amount of money out of Title I to make up that difference. Okay. Now here's something that I think is really going to apply to those tribes that are looking at possibly converting to a one grant for multiple number of schools. And under that one grant, can a grantee transfer funds among school sites? Yes. For grantees that operate schools at more than one site, they may expend at any school site not more than the lesser of, this is statutory language, 10% of the funds allocated for another school site, or maximum of $400,000 of the funds allocated for another school site. So if you have multiple schools, like at Hopi, we've got 7 schools. All of them will be grant come July 1, 2015. If at some point they decide they're going to go one grant, and they do, then they can move monies from school site to school site within that grant if a grant school, say one is running out of money or needs a little bit of help to fund teachers or whatever the case might be. This provision in the law allows that grantee to move money around between schools. Okay. Now, if the grant grantee subject to the administrative and audit requirements and cost principles for assistance programs. This is what I talked about a little while ago. There is something called administrative requirements and cost principles that are contained in 43 CFR Part 12. And the law 10297 specifically exempts tribally controlled school grants from these administrative requirements unless it's a new school construction grant or an FI&R project in excess of $100,000. Then the administrative requirements of 43 CFR Part 12 then applies. The only part that does not apply for new school construction or facilities improvement is how the payments are made to the grantee. If you have a FI&R or a new school construction project, the payments, the reporting requirements, financial narrative are all negotiated with OFMC, Office of Facility Management and Construction. I think that's still their name, out of Albuquerque. So you would negotiate with that office for an FI&R or a new school construction project in terms of how your payments are going to be made and how the reporting is going to be done. Those are separate requirements from your regular 100-297 grants. Okay? Anybody have any questions? Okay. How long is the eligibility to maintain a grant? And essentially, the eligibility shall remain in effect unless it is revoked by the Secretary of the Interior. How can an eligibility be revoked? There is a mandatory annual report that's required by 100-297 as amended by NCLB. And that report is limited to an annual financial statement reporting your revenues and expenditures as defined by the grantee's cost accounting system. You're required to conduct an annual financial audit conducted pursuant to the Single Audit Act. You're required to do a biannual compliance audit of the procurement of personal property in compliance with the grantee's procurement standards. Grantees are required to submit the number of students served and a brief description of the programs that were offered during that year. You're also required to conduct a program evaluation of the academic program according to the standards adopted by the grantee. Now, you can also meet that particular requirement if you are an accredited school. And what happens is, when you submit your annual report, you include a copy of your accreditation certification as a part of your annual report to both the tribal governing body as well as to the Bureau of Indian Education. And when the review report is done at whatever intervals those are done, then you can submit a copy of the review report done by the accrediting agency. Now, as long as a grantee submits its annual report annually, and these are due 90 days after the end of the fiscal year, which is June 30th. So all of the annual reports are due September 30th each year. As long as grantees continue to submit their annual reports, the Secretary cannot revoke your eligibility. However, if a grantee decides they're not going to submit the annual report, then it is possible that the Secretary could notify the tribe that because you are not submitting your annual reports, we are looking at revoking your eligibility to maintain this grant. Okay, so one way is by not submitting your annual reports, your eligibility can be revoked. The other one is accreditation. No Child Left Behind requires all schools to be accredited. So if a tribally controlled school is not accredited and cannot be expected to be accredited within 3 years, then it's possible that the Secretary could come in and revoke the grant. Now, if the school lacks accreditation, remember the screen previous, program evaluation of academic program? So if you're not accredited, then you need to have a program evaluation done by an impartial entity to take a look at your standards, your curriculum, to see how well or what you're doing to educate those students attending your school. Okay? Okay, payments and excess payments. When are payments to grantees paid? The first payment is to be made no later than July 1 and is 80% of the amount received in the prior year for ISEP transportation administrative costs. Now, if the BIE has access to funds from the Department of Ed by July 1, those dollars will also be put into the grant at that time, again based on 80% of what was received in the prior year. The second payment, consisting of the remainder of the funds that are due to the grantee, shall be made no later than December 1 of that year, that grant year. So if all goes well, we get money from the Department of Ed, there is an Appropriations Act enacted by the Congress for facility O&M dollars. Every grantee should have their total funds by December 1 of of a fiscal year. There has been times when that has happened, but more recently, more often than not, we've been seeing a lot of continuing resolutions. So our facility O&M dollars have been coming late. And that's another program that is, I'm not sure whether this on this slide or not, but that's another program. Our maintenance dollars right now are funded at 100%. However, our facility operations dollars are funded at approximately 50 cents on the dollar. So the formula says you're to get $100, you're getting funded at $50. So that's another area where we have not received full funding to fund all of our schools at 100% for facility operations. Okay. What happens if a grantee receives payment in excess of their entitlement? The grantee shall return to the Secretary such excess no later than 30 days after it is determined that a school was overpaid. Now, when does this happen? We have found in the BIE that at times schools that are eligible for transportation programs may change their bus routes from year 1 to year 2. And sometimes in the process of changing bus routes, they may get a reduction in transportation dollars. So say they got 80% of the prior year on July 1, and then the transportation count is done towards the end of September, and later we find out that the 80% that they got was more than what they would actually generate based on the September 30 count. Say they got paid $100,000, but after the count week, it's determined that they're only eligible for $80,000. So in that case, they were overpaid by $20,000. So according to the law, once BIE notifies the grantee that you are overpaid by $20,000, they now have 30 days to pay that money back to the Bureau of Indian Education. Now, what happens if they decide they're not going to pay the money back? And, you know, they're saying, you gave us the money, so we're going to spend the money. Well, if a grantee refuses to give that money back, what the Bureau normally does is they will send a notice up to the Interior Business Center up in Denver, Colorado, and they will request IBC to issue a bill of collection to the grantee. And if the grantee refuses to pay the overpayment, in our example, $20,000, then what happens is IBC then refers that to Treasury. Treasury then, once they get the request to collect on this money, will then reach into the pockets of the tribe and pull that money. There's a huge penalty that comes with it. Treasury adds on another 30% of what is due to the government. So if a grantee was overpaid $20,000 and say they didn't want to pay it back and it goes to Treasury, they'll end up owing the government, or Treasury will collect $26,000 from that tribe. For the most part, most of the grantees that do get overpaid will pay the money back. Not had a lot of problems with that, but those are some things that could happen. Okay. Can a grantee invest grant funds? Yes. Where? Only in obligations of the United States or in obligations or securities that are guaranteed or insured by the U.S. or mutual or other funds registered with the Securities and Exchange Commission that are guaranteed, and that's the key word, guaranteed by the U.S., or deposited only in accounts that are insured or are fully collateralized to ensure protection of funds, even in the event of a bank failure. Now, we've had some grantees that have been pretty ingenious in terms of where they're investing their money. Do not invest your funds in overseas bank accounts. We had a grantee that tried to invest in a bingo operation at one time. Do not do that. You are eligible and can invest these funds, but the investments must be very, very safe, and these funds needs to be protected because they're given to you to educate Indian students in our schools. So yes, you can. As I indicated a little bit earlier, there are provisions of Public Law 93638 that applies to 100-297 grants. And the first one is the single audit requirements. And these are the annual audits we just spoke to a few minutes ago. You have to do them. Now, there are Matt, I'm getting a thing on my Maggie Benali is requesting remote control of your shared desk. I don't know.
Yeah, I don't think we should probably share any desktop. But if anybody has any questions, I did see a couple people that looks like showed some interest in asking questions. And keep in mind that at any time, anyone in the presentation can ask a question. Just press *1, and you'll be able to speak with David.
We can take a couple of questions, Matt.
Okay. Yeah, I think this would be a great time. Cedric, can you? How about this, Cedric? Can you just open up the lines, and that way, we don't have to be in queue, and see how that works. And then we'll go from there.
Sure. As a quick reminder, if you're not asking a question, please mute yourself on your end.
Please feel something came back. That was
All lines are currently open.
the division manager. Where at exactly? Where did you have it? Just for the well, it's a specific form, I guess. There's another
Cedric,
form.
let's go back to the moderated lines. I don't know if that's going to work. It sounds like we're getting some feedback from a couple of people that have their phones open.
Yeah. Have the questions, Matt, or not?
Cedric, is anybody queued up with any questions?
No, I can monitor the quality here, but all lines are still open.
Oh, okay. Excellent. Thank you. Yeah, please feel free. If anybody has any questions, this is a great opportunity to ask, and we definitely want this, to be two-way communication and an interactive opportunity to talk with David today.
As a reminder, all lines are open. You do not need to press star 1.
David,
Yes.
this is Rosie. I had a question on reasonable, and I know what reasonable may or may not be, but if you really had to legally define reasonable, has that happened before, or?
Well, I think one of the things that you can look at is it comes down to the BIE has attached to it an administrative cost rate. For example, Part B, special ed money that comes to DPA, I think has a either a 3 or a 5% administrative rate that's attached to it. There's no reason why grantees can't use that same guidance in applying those rates to Part B, and then there's also an administrative cost rate that comes with Title I. There's no reason why grantees should not be able to use those same administrative rates to the funds that they receive from the Bureau. There's some Title I guidance. They're non-legal guidance, but that's available that speaks to administrative requirements for Department of Ed funds also. And I can make that available. Wendy, I can send it to you, and maybe you can send it out to everybody.
Yeah, I can do that.
Okay, I can make that available too, Rosie.
Thank you. Thank you.
Anything else? Anybody else?
Hello, David.
Yeah.
This is Victoria House from the Belmont Nation. We currently receive our Part B and Part C monies under Public Law 93638 for early childhood services. Now, can that be? I mean, can we move those funds if we decide to go, the 100-297 grant? Can we move those funds also to have one grant?
Do not.
No? Why would that not be advisable?
Actually, there is a separate grant form that we have developed. It's similar to 100-297, but because the law specifically speaks to K-12, and in the case of our FACE program, identifies those to be able to go into 100-297. Those are the programs that should go in. There is another grant form that we developed specifically for Part B and C. Now, I can send you those. They would be separate from 100-297, but essentially the mechanics works very, very similar to a 100-297 grant. Now, on those, you're still going to need to submit a scope of work and a budget narrative. But they're separate from 93638.
Okay.
They're easier to use, by the way.
That they're easier to use under...
And those are approved and awarded by the Bureau of Indian Education, whereas your 638 contracts are all approved and awarded by the Bureau of Indian Affairs.
Yeah, that I understand. I'm just thinking of, the flow of services that we receive. And so we receive 3 funds in our department from 638. Now,
And I have Marlinda Silversmith here in this office that can help you with converting it to that other grant form.
if we decided to, I mean, that's what we're currently, not, we haven't decided yet, but I just, just a question of whether or not that's possible. And maybe, I don't know if there are any tribes, that because we're, trying to look at seamless services in early childhood and actually special ed, so.
There are a number of tribes now that have converted to the new form that we use to award Part B and C for early special ed intervention programs.
And this is Marlinda, and I think one of the reasons why is because they received the funding a lot quicker than if they were getting funded by 638.
Under 100-297?
No, under the other
Format.
the other grant form.
That gets funded through BIE.
Okay.
So I think that's the major advantage.
Okay. Thanks.
Okay, anybody else?
David, this is Rosie again. Going back to the annual report, there was a practice that began years ago where the line officers were accepting the property outlined in the single audit versus a separate property inventory. And now the annual reports that I received do not have that property separate. And do we just note that?
Okay, what the law requires is that every 2 years the auditors come in and audit how personal property is being procured, whether they're following the grantee's procurement policies and procedures to be purchased. And if they're following it, then it will not be a finding in the audit. And that will be separate from actually conducting a property inventory. So they're looking at the process of procurement of personal property. And that's what they're auditing every 2 years. Now, we have a lot of cell phones. We have a lot of iPads, tablets, laptops that are being purchased by the grantees. And so the audit really is targeting looking at how those things are being bought and whether the grantee is following its own procurement mechanisms to purchase that property. And so that's really what the audit is looking at. Okay, anybody else? Okay, Matt, I think we can move forward.
All right, Cedric, could you please put participants in listen-only mode, and we'll continue on?
Okay, so we're at what provisions of 638 applies to 100-297 grants. We spoke to single audits. Now, there are certain things that happen if grantees do not submit their annual audits. If a grantee goes 1 year delinquent on submitting their mandated annual audit, what happens is the grants officer is supposed to put them on a level 1 sanction. That level 1 sanction requires the Bureau, the funding agency, to fund the grantees at 1/12 of what they're entitled to per month until the grantee submits the audit. 2, if a grantee goes 2 years delinquent on submitting their A-133 audits, the second level of sanction is the BIE will withhold 100% of the administrative cost grant funds until the grantee submits the audits that are delinquent. The third level of sanction, if the grantee goes 3 years delinquent on an audit, then the Bureau of Indian Education will put the grantee on notice that they are going to reassume the grant due to the audits not being conducted. That being said, there is a process the BIE must follow. 1, to notify the tribe. 2, to give the tribe an opportunity for a hearing on the reassumption. But those are the level of sanctions that should be applied according to internal requirements of the Bureau and A-133. Another provision of 638 that applies to 10297 grants is the criminal activities portion, the penalties. If someone, a school board member, a staff member, steals money over $100, the criminal penalties are they can be imprisoned on more than 2 years and could be fined up to $10,000. We have had situations within the Bureau where, these kinds of things have happened. Up north, we had several members that represented the grantee that actually went to prison for taking kickbacks from contractors and getting away with stealing thousands of dollars from a school. So, I don't anticipate that happening with anyone out of this group, but, it has happened within our grant schools. Wage and labor standards. Payment of prevailing wages and preference to Indians when you have a facility improvement and repair project or you have a new school construction project. Another provision is retention of federal employee coverage. What the provision says basically is that if a governing body requests to convert a BIE-operated school to a tribally controlled school, they can actually allow employees of that grant school to maintain their federal pay, their federal benefits when they convert to the school. Now, that provision allows grantees to do this, but I have not seen a lot of grantees adopt adopting and implementing this provision when they convert their schools from a bureau-operated to a tribally controlled school. But it's available. Another provision is use of federal property. Once you convert to a tribally controlled school, you can use the existing school buildings to carry out the program on behalf of the federal government, educating students. Now, use of existing buildings is fine, it's perfectly fine. However, tribes are also given notice that when you convert a BIE-operated school to a tribally controlled school, the transfer of property is pretty automatic unless the tribal governing body specifically states it does not want title to the federal property. My recommendation is to leave title with the Bureau of Indian Affairs. And one reason is the BIE is being scrutinized, I think, pretty carefully by EPA. And they've conducted several site visits to some of our boarding facilities and some of our schools. And we found that if a tribe owns the facilities, then the tribe would need to deal directly with EPA on any compliance issues found by EPA. However, if the Bureau of Indian Affairs keeps title to those facilities, then the BIA, along with the grantee, is responsible for compliancy to EPA non-compliance issues. So I would simply recommend that, for now, if a school does convert, that they keep title with the Bureau of Indian Affairs. Lease a facility for administration and service delivery. If a tribe has a facility that they would like to lease back to the Bureau, in carrying out services, tribes can do that. Limitation on remedies relating to disallowed costs. Notice within 365 days. What the regulations require is that once an audit comes in, once the Bureau, we have an accounting, an office in Reston, Virginia, who actually officially receives the audits, and then they submit it out to the grant officers. From the date that the office in Reston receives, I think the office is called Office of Audit and Evaluations. Once they receive the audit, they notify the grant officer. Within 365 days of receipt of that audit, if there are question costs in the audit that later becomes disallowed, the Bureau has to notify the grantee within 365 days and make a final determination on the disallowed costs within that 365 days. If the Bureau does not make that management decision within 365 days, then essentially BIE has given up its right to collect on any disallowed cost if it's not done so within the 365 days. Another one is use of grant funds for matching, meeting matching requirements for federal and non-federal programs. This provision allows a grantee to use their grant funds for matching purposes for other grants that they might be applying for. Some grant requirements sometimes that are putting funds out there require a matching amount. So the law says, or at least, the law says from 638, says you can use grant funds for matching purposes. Allowable use of funds. Grantees can expend these funds without further approval from the Secretary for allowable purposes to carry out the program. So once you receive the funds, and as long as you're expending those funds according to the program requirements, you do not need to come back to the Secretary to request approval to expend the funds. Now, in all cases with 100-297 grants, again, the education line officers are the grants officers who represent the Secretary. So if a grantee is going to look at spending money for other than the purpose for which the funds were appropriated, then that grantee has to touch base with the grants officer who must provide approval. But other than that, if it's within the guidelines of the program, you don't need to come back to the Secretary to ask permission to expend those funds. My froze. Matt, my screen froze. I can't go to the next one.
Are you good?
It's not. Oh, there we go. Okay.
Okay.
Okay. There's some other provisions from 638 that applies to 100-297 grants. And under the provision of model agreements, there are a couple relating to limitations of cost. Contractor not required to continue performance that requires expenditures in excess of amount received. Now, we've not normally seen a grant school shut its doors because they don't get enough money. But apparently, if push comes to shove, if you don't have enough money to operate the school, then you need to get with the grantee and see how we can get that rectified. In terms of relating to records and monitoring, tribal control school grants actually should be monitored, just like 638 contracts, where BIE needs to come out at least one visit annually, unless the grantee agrees to more, or if there is a reasonable cause to require more. Now, the Bureau of Indian Education in its realignment, will need to address how these monitoring visits are to be made. So I'm sure you'll be hearing a little bit more about how that's going to be done, but the provisions of 638 requires that we're supposed to, BIE is supposed to be out there at least one time annually for a monitoring visit. Property. All the property within BIE schools is going to be transferred to the grantee. All the computers, all the copy machines, telephones, whatever else is sitting inside that school as property will be transferred to the grantee once the school is converted to a tribally controlled school. Now, this is where Rosie brought up the issue of property. Now, when you convert, the Bureau of Indian Affairs, working with the grants officer, BIE, needs to sit down with the grantee and spell out the property inventory list and check off which pieces of equipment and property are being transferred as a part of the transition from BIE to tribally controlled. The grantee then will build its own property management system based on the inventory listing that's provided by the Bureau of Indian Affairs and BIE to the grantee. Once that happens, then the grantee is totally responsible for all the equipment and property that is transferred to the grantee. The grantee should conduct a property inventory at least once every 2 years, but it's better if they do it once a year because they're going to be purchasing property annually, I'm sure, and equipment. Now, when it comes to records, what's going to happen is, according to the records management people out of Albuquerque, all of the original records, student records, records of the school, all the originals of records that are going to be transferred to the grantee, they all have to be copied. All of the originals has to go to Lenexa, Kansas, to our storage facility. So any record that's going to be transferred to the grantee has to be copied, and then they get copies, and then from that point on, they start developing their original records for the school. And it's up to the BIE during the transition from, I would say January, February to June 30th to make sure all of this happens and the grant school is ready to open on June 1st. July 1st. The other provision of 638, these funds that go into the grant, once they go into the grant, are available until expended. So even though, say like Title I, Department of Ed rules state that 25% of Title I can be carried over from year to year. 102.97 and 638 says that these funds, once they're incorporated into the grants, are available until expended. More provisions. We spoke to reassumption a few minutes ago. There are two other reasons that a grant under 102.97 can be reassumed. The first one is violation of rights or endangerment of the health, safety, or welfare of any persons. When might this happen? Well, we had a situation at one of our grant schools where apparently the background investigation results were not adjudicated properly because we had a cook that had been convicted of murder serving as the head cook at one of our grant schools. If a grantee knowingly does not conduct background investigations and we hire folks with those kinds of backgrounds, we are violating the rights or endangering health, safety, or welfare of our students at our grant schools. And background investigations are a requirement of Public Law 101-630 and Public Law 101-647, which requires background investigations to be done. So if it's found that something like this is going on, that's a cause for the Bureau to come in and let the grantee know that they're going to reassume the grant. The other one is gross negligence or mismanagement in the handling or use of funds. So in the past, we've had a couple of grant schools that were reassumed because of gross mismanagement of federal funds. So if it's found that the grantee is misusing federal funds, then the Bureau can come in and put the grantee on notice that they're going to reassume the grant. Again, there's a process that has to be followed by the BIE anytime they're looking at reassuming a grant. And it can be a long, drawn-out process, but we have to follow it. Sovereign immunity and trusteeship rights unaffected. Nothing is construed to affect, modify, diminish, or otherwise impair the sovereign immunity from suit enjoyed by tribes. Authorize or require termination of any existing trust responsibility of the United States with respect to Indian people. So these grants in no way impacts sovereign immunity of tribes, or do they terminate any trust responsibility the United States government has in providing an education program to Indian students. But it is an opportunity for local control. Couple more questions. Are grantees covered by the Tort Claims Act of the federal government? Yes. Now, this impacts the risk assessment program that a grantee has to develop. And your risk management program includes procurement of liability insurance. Tort claims applies when you are carrying out the program requirements of the grant. But if you have a situation, for example, a lot of the schools allow the communities to come in and hold community basketball tournaments, which are not necessarily school related. So in those instances where it's a non-school board sanctioned activity for the school, but it's a community situation, then the grantee should look at purchasing some liability insurance for coverage in case somebody gets hurt, during these activities. There are tribes out there, with good liability insurance coverage. And tribal organizations, I'm sure, could enter into agreements with the tribe to be covered under their liability insurance program possibly. But in other instances, the Tort Claims Act covers the grantees. There are deadlines that you have to meet when a tort claim is going to be made against the federal government. A claim has to be filed within 2 years of the event for it to be covered under tort claims. And it goes to the funding agency, and then it'll eventually go to the solicitor's office, who will make the determination on approval, disapproval of the claim made against the federal government. We spoke about this a little bit. Are grantees subject to background investigations? Yes. Public Law 101-630, which is the Indian Child Protection and Family Violence Prevention Act, and 101-647, which is the Crime Control Act of 1990, requires the background investigations. And by the way, there are no statute of limitations. If you are convicted of 2 misdemeanors or a felony, if you've been convicted of 2 misdemeanors involving crimes against persons, prostitution, physical violence, or a felony, you will essentially be forever barred from being employed under 101-630 and 101-647. Okay. Questions?
Cedric, can you open up all the lines so that people can ask questions?
All lines are currently open.
Thank you.
Any questions out there?
David, this is Wendy. I I think because this is going to be used for future webinars, and as tribes start to pull their teams together to research the frameworks for the Sovereignty in Indian Education grant, I wondered if you could maybe highlight some areas that in a research consultant's analysis of a school and the schools and the tribe, what should they be looking for when they're evaluating a system that would fit around the Public Law 100-297? What kind of questions should they be asking themselves?
Sure. Obviously, when you have a one grant versus one grant with multiple schools versus a grantee that has one school, things are going to be a little bit different. When you start looking at one grant, just like they have in Choctaw, Mississippi, you're going to need to start asking, from an academic standpoint, how you're going to align the standards. How are you going to align the curriculum to line up with the standards? You're going to start looking at developing a budget from more of a school district level than you would a single school level, although ultimately you're going to be looking at a budget that's being developed for multiple schools, and how you're going to get that money out to the schools. And keep in mind that even though you go into, say, one grant and set up a school district, each school is still going to generate its own revenues, which then will go into the grant. If you have 5 schools, each of them will generate their own dollars, their revenues, based on the student count, based on their transportation miles, and then it'll go into the grant. Now, one thing that I would really recommend that you guys start looking at is how administrative costs, what is it going to look like if you go into one grant, and how that administrative cost is going to be spread, particularly if you're going to be utilizing the tribe's accounting system, their HR system. You need to start looking at how much it's going to cost you to buy accounting services, how much it's going to cost you to buy procurement services from the tribe, how much of the administrative cost is going to be used for those purposes, what your share of liability insurance premiums are going to be, and along those lines. What you're going to need to do is look at each of the schools and look at the performance of the students. You know, where are we in comparison to the standards? And then develop your budgets to address those areas where you are behind or deficient in terms of comparing to where the standards are and where the performance of the students are. You're going to need to, do probably more public relations in terms of what the plans are, for the district, or for the one school district that you're looking at. How you communicate that to the stakeholders, to the teachers, staff, school boards, tribe, parents, community. All of that comes into play. And I'm not sure, Wendy, if that's the kinds of things that you're looking at, but...
No, I think it's perfect. I think another question that I have as tribes develop their framework is addressing some of the major challenges that typically confront grant schools. What are some of the biggest audit concerns that generally impact grant schools that if the tribe was assuming one grant that they would have to consider as they move down their pathway of how to address those challenges confronting their grant schools right now?
I think there's something that they refer to as internal controls that should be at the forefront of everything that tribes are going to be looking at under the one grant concept. And in essence, internal controls do a couple of things. And they are policies and procedures designed to protect the assets or minimize the possible risks associated with finances. And they also are designed to assist the grantee in reaching their objectives and goals that the grantees have. For example, I think one of the things that I found that really needs to be looked at initially and critically important is the governance system of the board. Bylaws, how they govern themselves, how they take action to act on items for the school, who sits on the school board, what qualification requirements should we imposing, if any, on school board members sitting on our grant school boards. They need a very, I think, well-defined financial policies and procedures manual that has a lot of internal controls identified and spelled out in the manual itself. Because at some point, one, it's going to address A133 audits. It has to meet the requirements of an A133 audit. And then it has to be viewed as something that's going to control and protect finances of the school, as well as help them educate those students and meet the standards, the objectives, and the goals that they've set for that school. I think HR systems, for the most part, tribes do not necessarily include education requirements or employment of educators in their HR systems. So I think these grantees are going to need to develop systems that specifically address how we deal with hiring, payments, discharge, performance appraisals, recruitment, all of those things specifically addressing how we hire and deal with educators. I think tribes probably have good HR management systems. They just need to make sure that educators are included as a part of that. And I find that one of the other shortcomings that may exist out there that they really need to take a look at and address is training for school board members in terms of how they operate a school, what their responsibilities are, what the responsibilities of the staff are. And I think that distinction really has to be made. And school board members educated on what their responsibilities are in terms of policy, budgeting, total arena of finance, academic standards, all of those things. I think school boards, they don't have to become experts in it, obviously, but they need an understanding of what those things are all about, particularly budgets and the standards.
Okay. One last question that I had is under what authority do tribes have in obtaining financial data from their grant schools? Because I know that as the tribes begin examining the current state of their school systems, they're going to be inquiring about where do we obtain the financial data about our grant schools. So I just wanted that specific question, which has been posed to me in the past, responded to through the Public Law 100-297.
Under one of the provisions that we just went over, monitoring, the BIE can go in and monitor at least one time annually the grants of each grantee. And as a part of that, the Bureau can look at all records of the grant, including financial records. So the provision, I don't remember which one it was, but one of the provisions allows the Bureau to go in. And they also have to make records available to the Bureau for 3 years, up to 3 years back. So the BIE has an authority to sit down with the grantee and look at the financials based on that provision of 638 that applies to the grants.
Okay, maybe we could find the provision later and then email it out to everybody afterwards, okay? Okay.
All right, hang on. Okay, it's under Model Agreement Provisions of Public Law 93638. I'll have to give you the citation. But relating to records and monitoring, record keeping and routine monitoring limited to 1 visit annually. So it is, I can send you the citation, and then you can send it out. But yeah, that allows us to go in and monitor at least one time annually.
But that's for the BIE, but for the tribes themselves, they do have the authority to go in and monitor or obtain records more often than once a year, right?
Oh, okay. I'm sorry. I misunderstood your question.
It's from what authority do tribes have in obtaining financial data for their grant schools?
And that's a great question because ultimately the tribal governing bodies are responsible for these grants. And they're responsible because the law requires tribal governing bodies to authorize grantees or school boards to receive the grants. The tribal council, the governing body, can change the requirements of how it does business with that grant school. They're not school board organizations. They're not school board. The schools do not belong and really are not operated by the school boards. They're given day-to-day authority to operate the school under the authority of the tribal governing body. So a governing body can change the resolution or require that school board to provide financial data. Or it can retrocede, and I'm not sure we talked about that today, but the tribal governing body can do a lot of things with that grant. They can give it back to the government. They can put it in a 638 contract. They can also set rules for how schools are operated under their jurisdiction. They're totally in charge. The tribes are.
Thank you.
Is there any other questions?
Any questions? Neither in here.
Matt, if there are no other questions,
Yeah, let's give it one more call. Just a quick last call for any final questions. Any of the participants in today's meeting. This is an opportunity to ask any questions if you have in regards to grants.
David, this is Rosie. Have you reviewed the super circular real well?
I'm sorry, have I reviewed what?
The super circular real well, and if there's any major changes.
I've kind of did a quick review. I haven't memorized it yet, but they're pretty much it's the same. There's going to be some minor changes, but I really haven't read it that well yet.
I think the only one that I saw was where it's changing the federal awarding requirements up to $750,000.
Okay.
The audit?
Yeah, but in the if you search, I'm not sure what website, there's actually a comparison of what changes were made to the circular. Otherwise, they combine all those circulars together.
Why don't you get that and send it to Wendy? Wendy can send it out.
Okay.
And Wendy, we'll have Marlinda send it to you. Then you can send it out.
All right. Okay.
All right. Well, that's a good question, and we appreciate all the questions that we have. Some of the, I guess, the benefit that we've gotten out of these presentations in the past is if someone raises a question, sometimes it'll spark another question, and it opens up the discussion. So we've still got a few, 40 minutes left on the clock for this meeting. Does anybody, I guess we'll go last call, does anybody have any final questions or anything else that they want to ask in regards to grants today?
You gonna go over there and meet with him on that?
All right. Well, I think that we'll wrap it up here then. And thank you very much for everybody that attended this meeting and this presentation. David, thank you for presenting, and thank you for attending. Have a wonderful rest of the day and happy holidays.
All right, thank you. Goodbye.
Thank you. And that concludes today's conference. All parties may disconnect at this time.